Hey folks, Mark Scroggins back with another edition of Family Law Talk. I have Blake Rudd, another lawyer with our office.
Hi.
How are you?
I'm good.
Good. Well, I wanted to talk about a couple different issues today. So, people get consultations set up all the time. As you know, one of the things, you also get attorneys who do free consultations. And as you know, we do not do those. And my thought has always been, if something doesn't have value to you, if you don't have any skin in the game, there's absolutely no reason to be reasonable. So going past that, what do you tell people that they should be able to expect is going to take place in a consultation?
Well, let's go back once before that. Early in my career, I was one of those free consultation attorneys.
Right.
And let me tell you, you have no shortage of potential clients when you offer free consultations.
That's right.
And you get about 98% tire kickers, and the majority of your day is spent doing free consultations.
That's right.
Which allows very little time to actually work on your client's cases. I believe that when a client pays for that consultation, they come in more well prepared.
Right.
They're more likely to actually complete the intake paperwork, maybe even forward you the pleadings ahead of your meeting so that you can review a prior order and give a better consultation.
Right.
It's just an all-around better experience for everyone, and the attorney is more likely to take that time seriously because he knows he's been compensated for it.
Right.
And
yeah, I think those are all really good points. So, the big thing, it's kind of like, and this happens at times, where you end up with, you can end up in some pretty heavy litigation that goes on, and neither side is actually paying their own fees. They're being paid by a family member. And so the folks who are getting killed in this thing are the folks paying the bills, because since neither kiddo has any responsibility, there's no reason for them to be reasonable, and they can just keep spending mommy or daddy's money.
we see that in they're essentially grandparent cases without the grandparents being parties to the case.
That's right.
Where somehow these grandparents raised individuals
Right.
that did not mature, and then they find themselves in the middle of family litigation, and you got grandparents on both ends fighting through their children.
Well, and sometimes, that's kind of an extreme example. There are also a lot of, most of our clients, they come to us because they've got pretty heated litigation going on, which is kind of, where we've built a reputation, I think. And so it's really great to have parents that can assist with the bills, because child custody litigation really nasty divorce cases can be unbelievably expensive to litigate.
Yeah, and I guess it kind of goes back to skin in the game. When they're floating their own bills,
Yeah,
they seem to listen to the advice we give them a lot better.
that is absolutely right.
And and we give good advice, I think, most of the time. And so when you have somebody who's not financially invested, they're not really listening to the attorney because they're not paying for the attorney, and in return, it can be hurting their case.
Well, so going back now to a consult. What do you think a client or a potential client should expect to receive in a consult?
Well, it's kind of a two-way street. Some clients come in with very few questions because they just say, I need a divorce and I don't know anything about it.
Right.
Some clients come in with 100 questions and they end up consulting you because you get about 3 words in on the consultation. And I think the happy medium there is a client needs to be prepared for the consultation by thinking of a reasonable amount of questions. Here's really what I'm trying to get out of this, but then also allow enough time for the attorney to kind of explain the process. I mean, you're here to talk to us for a reason, and I've been in both, where you get some clients, they come in, they say, here's what we've got, okay, the house, and they got very specific questions, and then they still allow you enough time to get into stuff that maybe they haven't thought about. There's
Right.
a lot of questions that should be asked of them, and things that they haven't thought about, and that's what we're there for.
Right. So I think it's completely reasonable when somebody comes in. Let's just talk about a divorce, for example. I want to tell someone what a divorce looks like in Texas, right? So what the law is, what the presumptions are, 2 pieces to a divorce case if you've got kids, right? Child custody and property division. A lot of people think they know what, because Texas is a community property state,
Right.
they think they know what that means. And very rarely do people really understand what the ramifications of that are. And based on then what the facts of their particular case are and the application of those to the statutes and the presumptions and things, kind of telling them what they can expect for, the case to look like over what period of time and what does that mean.
Yeah, the timeline question's one that often they don't ask, but I feel compelled to go over at the end of each consultation anyways, because that's also not something you can really find online when you look at things, because it varies so greatly.
Sure.
We know at minimum it's going to be 2 months, basically, and that's pretty extreme or rare for that to happen.
Extremely rare.
And then it can range up to 1.5 to 2 years on some of the longer end. Most of your stuff falls in between that, but just to not only walk them through the timeline of the case, but how the legal fees kind of go along with that. It's not a constant. It's up and down, up and down, and things that you can do to mitigate some of that by working ahead, looking ahead, and then just planning, because a lot of what we do, because it is expensive, is managing a legal budget.
Right.
So I like to talk about that in my consultations.
Yeah, I think that's really important. That goes to one of the things that I think is the most important, which is setting the expectations. So I think the client needs to provide adequate factual information to the lawyer so that the lawyer can take the knowledge of the law and apply the two together and kind of tell you, what that comes out with is the final recipe, right?
Right.
How do you get from point A to point B? How would you do that? How would you do that as compared to, what others might have told them? We tend to, I'm always a believer in being very aggressive, but that doesn't mean that, every case needs to go to trial or things like that. There's a time to resolve things and there's a time to fight about things. And obviously if you can resolve it, where both people go away feeling a little uncomfortable, then you probably got a good deal there, and that's probably a good thing. But there are just times that you can't, and so people need to be prepared to understand what the likelihood is that the other side's going to roll on something, and as compared to what the likelihood is that you're going to have to fight about that.
Right. Well, and a lot of times clients come in thinking they have a smoking gun.
Right.
Because of this, I'm going to get 100% of everything. And that is really where coming to setting expectations, where that comes into play.
Right.
Because you have to explain to them that this judge hears everything every day.
Right.
And it's likely a lot worse than what you're even talking about.
Right.
And so you got to remember or inform them of who the crowd is that they're going to be speaking to.
Right.
And what they might consider terrible versus you don't want to minimize anybody's problems because it's all relevant to their personal life, but you do need to remind them who they're speaking to and what they see on a day in, day out basis. Another thing that, to get back on the consultation, another thing that I like to do and I feel like is beneficial for a client is I leave them with basically a to-do list.
Right.
At the end of each consultation. And they can take that, I feel like that kind of starts forming the relationship with myself, but they could also take that recommendation to wherever else they go after if they choose not to hire us. But things that they can just go ahead and start gathering these documents, especially before you file a divorce. Because, the first thing that will happen, even though you're not supposed to, as soon as it gets filed, passwords get changed, you get removed off accounts. So if you can tell a client, look, go ahead and start gathering this information.
Right.
You can really put yourself in a better position. So I like to give them a to-do list even after the consultation.
Yeah, I think that's all really good information. So here's something else I wanted to talk about, because we hear all about someone's a father's rights attorney, and what is the difference between a father's rights and a mother's rights attorney?
Advertising.
Yeah, exactly. So there's absolutely nothing in the statute that is specifically geared towards one gender or the other. As a matter of fact, the court isn't allowed to consider that, are they?
Absolutely not. It's an advertising ploy. And one questions why you would advertise to one sex over the other or one role over the other. But must be effective because there's a lot of attorneys out there to do it. But when it gets down to it, there's no such thing as father's rights. There's mother's rights. There's only parental rights.
Right. So as a matter of fact, there's a statute that says that you can't have any discrimination based on sex or marital status.
Right. It's codified.
So, yeah. So that is something that's important to remember. Now, something else that people should know about that happens every odd year, because Texas legislature's only in session on odd number of years, is there has been stuff, God, I don't know for how many sessions now, that has been filed about starting at 50-50 instead of what is known as a standard possession order.
And I looked briefly before walking in here, and it looks like it was introduced again in 2021.
It was, right.
And it looks like it was left on the table again in 2021.
Right.
It's something that people are pushing for. Whether you think it's good or bad, I don't know. I think that it's probably the fairest way to start, because right now one of the problems I perceive with the current possession schedules, conservatorship laws that we have, is that it makes both parents feel like they're in a competition.
Yep.
There's going to be a winner and there's going to be a loser. And sometimes you need a winner and sometimes you need a loser. But most of the time, and a lot of times, you just have two good parents that they don't want to be married anymore.
Right.
So why should one be a winner? Why should one be a loser? That may make me sound like I'm a proponent for the 50-50, and maybe at heart I am. I just feel that, it would be best for a child. The children see that too. Oh,
yeah.
Okay, mom won, dad lost. I'm with mom more. I'm less with dad. Maybe that means mom's the better parent. I don't know. I would not be opposed to that change.
It's interesting because, the standard possession order is, the presumption is that is the minimum amount of possession and access that the non-primary parent should have. But it's not treated that way, I think, most of the time.
A lot of judges treat it like it's the maximum amount.
That's exactly right.
And maybe you can get up to the expanded standard possession schedule, but it seems that that's more of a cap than it is a minimum.
Yeah. So those are a number of things, folks, that think about. If you are setting a consult, whether it's with us or with somebody else, go in with a list of questions that you need answered. Based on whatever the case is. Be ready to provide a factual recitation of these different things. So if you're wanting to know how is our marital property going to be divided, be prepared to provide your potential attorney with a list of the different things you have and what the values are on those. Otherwise, it's difficult to provide any.
It's like walking into a doctor's office and saying, "I'm sick." Well, what's wrong with you? What are the symptoms? I don't know.
Yeah,
I'm
you
sick.
figure it out, Chief.
Yeah.
So if someone wants to get a hold of you to set something up, how do they get a hold of you, Blake?
Well, the best thing to do is call 214-469-3100. Call. We can set it up. We make ourselves available as quickly as possible.
Right.
We're very responsive, and I know that most people are stressed, especially once they've made the decision to get divorced, or they found out that the other spouse has filed divorce or hired an attorney, and you want to speak with somebody quick. We understand that, and so we get appointments scheduled pretty quickly.
Yeah, folks. So 6 lawyers currently at Scroggins Law Group between our Dallas and Frisco offices. So we've always got somebody that we can set up with you, and we understand the emergency that you can be facing, and so we make ourselves available to handle whatever kind of difficulties you have. So just like Blake mentioned, you can get us, call in the office, 214-469-3100. You can also reach us at info@scrogginslawgroup.com. If you've got any questions, reach out. If you want to talk to me or Blake or any other lawyer at Scroggins Law Group, let us know. We're here to help you. Have a great day. Bye-bye.
Thanks.